yourself a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yes, indeed, that real good lawyer is, of course, in the studio because it's Tuesday morning. And a big welcome to David Whiting. Hello.
Hello, Ellie.
How are you?
Very well,
Long
thank
time
you.
since I've actually eyeballed you.
I think that's right. We've all been off doing busy doing other things and, yes, doing everything remotely.
Doing everything remotely, including, still doing this segment, of course. 1300 222 774 is the number if you would like to talk to David Whiting. And David, I know you didn't have homework, but you have been alerting me to a couple of interesting cases. In fact, very similar cases, but to different. They're taking them to different jurisdictions.
Yes, they're Qantas staff. They've got a federal court action. That is Qantas staff who don't want to get vaccinated, and they're gone to the federal court to protect their positions in relation to Qantas's stand-down or termination provisions as a consequence of failing to be vaccinated. And on Thursday, an application will commence in the Fair Work Commission by Virgin staff on pretty much the same principle.
And what are they arguing?
Well, I'm not full bottle on the federal court one, but the Fair Work Commission is essentially suggesting that there wasn't enough research done by the airline in relation to the consequences of vaccination on staff, and therefore the decision was essentially premature.
Okay. Do you think we'll get a resolution to this in the shorter term, or will it take the wheels of justice grind slowly? The
wheels of justice grind very slowly, and in COVID they grind more slowly. So, look, I think... all of these issues depend on their particular facts. No, I don't think we'll get an answer that'll keep most of the population happy.
A very confident view there. Optimistic. There you go. Okay, 1300 222 774. Dee in Carnegie. Good morning, Dee.
Oh, good morning, David and Ellie. Thanks for taking my call. My query today is I obviously need to know where I stand legally and my rights. My car insurance policy states that I'm entitled to a glass replacement per annum and you don't have to pay in excess, which I had a claim in 2019 and I used the glass company that they recommended because when you call you get put straight through to the glass company.
Yes.
That was all good. Got the windscreen. They had trouble. Now the policy states that they will supply an aftermarket in that, let's call it, the deal.
Yes.
Aftermarket, unless they can't source an aftermarket, they'll give you genuine, which happened in my case. Now, the glass company had trouble sourcing the glass, and I put them onto a chap that had the glass that was suitable. So
but you did get one at the end, did you? So where are we now?
Where are we now? So there was problems when it got fitted. They damaged my car and there was a whole lot of issues. Got sorted, all good. Recently in January, my husband had to do some work on the dash and he wanted to take the dash pad out, and we've found that the dash pad has been glued from the inside to the glass.
Yes.
So can't get the dash pad out. So I contacted the insurance company who...
When you say the dash pad, you mean the dashboard, do you? The top of the dashboard? Is that what you mean?
Yes, the dashboard. So
yes.
This is a classic car. It's an American car. So we couldn't get the dashboard out.
Yes.
So I contacted the insurance company.
I think your claim is against the company that
put the glass
in. I was involved in a car accident a couple of years ago as the owner of the vehicle, and no, it wasn't my fault this time. And what happened was the insurance company from the other side wanted me to use their repairer.
Yes.
Because they own repair companies as well. And my view would be, I said, I'm happy to if you guarantee the performance of your company, and they weren't prepared to go there. So effectively what they've agreed to do is pay the glass company that did the installation. Your claim is against them, all right?
Yes.
And it's a matter that you could take to VCAT.
That's going to be because I'm getting nowhere. So I've got in contact with the insurance company. Now, another thing that came to light with all this...
Just be brief, Dee, because I do have a full board of calls, so I want to give other people a go.
The glass is the incorrect glass fitted. It's not... I've got a copy of the invoice supplied to the glass company.
Yes.
$1,000 glass. They've paid for it. A $200 glass went in. So the glass is not the correct one. I'm arguing I want the correct glass put in.
Well, I would. At that stage, it then comes down to reading what the policy and what the contract specifies in terms of the glass that's provided. Now, you've got glass that fits, or is the difficulty that the glass that they've provided doesn't quite fit because it's not quite the right glass? That could be your problem. So
yes.
I would be trying to find out what the glass is that they put in as opposed to the glass that's there. But your claim's against the glass company.
Dee, good luck with that one. Simone in Montrose. Hi, Simone.
Yes, good morning. How are you?
Good.
That's good. I have a fence. I've asked the next door neighbours to put up for us to replace the fence. I've been living in my property for 31 years, and they've been living in their place for 7 years approximately. They stated they would agree to have a fence, but they are going to get some surveyors in order to check what the boundary line actually is.
Yes.
I don't know where I stand. I actually think that where that current fence is incorrect. So do I have a case for adverse possession?
You could make a claim for adverse possession if you want to. And you could, if you want to, if in the event that the matter goes to the Magistrates Court, one of the issues that the magistrate is now entitled to determine under the Fences Act is the right boundary. So, you, whatever you now occupy and have occupied for 31 years, you get to keep.
Oh, good. That's all I want. I don't want any.
So what you need to do is perhaps arrange your own survey for the purpose of considering an adverse possession application and to decide whether it's enough for you to have a fight about. I mean, if it's only 3 or 4 inches, it may not be worth the effort. But if it's,
And Simone, if you're going to keep what you've already got, would you need to do that?
No, you don't need to, because their right to recover it is extinguished. And
right.
So you don't technically need to. But I would be wanting, if I was in your shoes, I'd want to know precisely how much I occupied but didn't own. All right?
And what are the rules on that in terms of that you've occupied it for 31 years, therefore their right is extinguished?
Yes, it's called the Limitation of Actions Act, and what it does is it prevents the neighbour putting the fence back in the right spot. It takes away their right to recover possession of the adversely possessed land. Now, from the point of view of a person who's doing the adverse possessing, the occupation needs to be for a period of 15 years and upwards. So at 14 years and 9 months, you don't get it. If the 15 years is over disjointed periods, you don't get it. So I've seen one in the last couple of weeks where the issue is really my client bought the property 3 years ago, now find that inside their fence line is a little bit of someone else's property that they want to keep. What they need to do is go back to their vendor, to their seller, and buy whatever rights of adverse possession their vendor had. So you can use someone else's possession to make the 15-year block.
Okay. It's interesting, though, because if a fence has fallen down or you do have to entirely replace it and you probably are wise to do something like that to try and find out exactly where the fence line should be.
Well, the premise is that you'll put the fence back on the same line because the starting premise is the fence is where the fence belongs. But it's my recommendation to everybody that the moment you're starting having a fencing problem with your neighbour is lots of pictures that enable you to locate precisely the fence.
And if you're outside a metropolitan area, the fence may not be quite so clear. It may be made up of bush or blackberries.
Yes, I have a rural fencing issue which is substantially offline.
Right, okay. David in Colac, good morning.
Good morning.
Hi.
How are you?
Good.
I've got new windows in a new house, and they're leaking. And I've tried to contact the company on numerous occasions.
Why is your claim not against your builder, David?
The builder has stated that the claim is, or the windows, it's the windows that are leaking, not the
not the way they're mounted, is that right?
Yeah, the implementation.
So it's almost like a warranty claim because something's getting between the glass and the frame.
Spot on.
Yes. Okay.
Now, they're not replying. They made an appointment to come and test them yesterday. They've not even given me the courtesy of a call, we're not coming. They will not. They just don't correspond. What can I do?
Then it's a claim under the warranty. It's a Consumer Law and Fair Trading Act claim, and you would bring it at VCAT. And it would be for either the repair or replacement, but you need to start for getting a quote as to whether they're fixable, and if not fixable, what will it cost to replace them?
So where do I get the quote for? Do I have to go back to the builder? Go back to the company?
Well, they're not going to give you a quote to replace their windows because what you really need to do is find an equivalent window, and the builder might give you some guidance there. What would be an equivalent window? You then go to them and say, can you fix it? It may be that you need to remove the glass and replace the glass. I don't know. Somebody's got to actually work out how we fix the problem.
Yep. David, good luck with that one. Chris in Forest Hill. Hi, Chris.
Good morning.
Far away, Chris.
Thank you. Mine is a three-way problem, but first I'll mention I sold my house in December. Settlement is in the middle of May. During in between that time, a curbside waste collection truck came along and inadvertently pulled down a cable connected to my house, pulling the fascia board off the house. The next day they left a notice clearly identifying they had done it in my letterbox. So I got in touch with the council, who were polite and very kind and very helpful, but basically were saying, you need to get in touch with the telecommunications company.
Chris, we had a similar call a few weeks ago. And in that particular case, the issue was that there was I think there was a minimum height requirement for the...
That's correct.
For the droop from the cable, but there was also council trucks that were slightly taller.
Well, I'm not aware of any of that. My concern is when I got in touch with Telstra, they basically say, no, go and get in touch with your house insurance, which I might have an excess on. My concern is it worth pursuing away from the house insurance, or have I just got to cop it sweet? And/or can I leave it for the next owner of the house? That's why I mentioned the phone.
What's not connected, Chris? Just the telephone, or?
Well, first of all, I need to clarify. It's a Telstra cable from when I used to be a Telstra company. I did actually ring the telecommunications ombudsman ahead of ringing Telstra,
yes,
and they said to me, "Oh, you're not a Telstra customer, so we can't act for you."
I like you preempting there.
Okay,
Chris.
I'm impressed, Chris. Chris, can I think about this for next week? Because it seems to me the issue is the council and the droop on the cable. Although the usual practice would be that when somebody like Telstra or indeed any of those providers, when they stop providing your service, they normally leave the facilities in place because another customer might come along. But then if you've got a telephone cable and an NBN connection, which I guess you would have, then there's an amount of duplicity there, but no one's got a budget for clean-up. Don't know. I'll let you know next week, Chris.
Chris, homework. There you go. David in Geelong. Hi, David.
G'day, how are we going this morning?
Good, thanks.
Yeah, David, I bought a block of land a couple of years ago up at Corningham. It had a dam on it, and the dam was leaking. So I got one of the local blokes who was working on the road on dams, got him to come and fix it. Like he said, I'll have to pull it all out, scrape it all out, and rebuild the wall. I said, yeah, well, you know what you're doing, go for it. But what happened after we had a decent rainfall and the dam actually filled, the wall, where he was supposed to repair it, is leaking. And all the water leaked out. And I've been trying to take occasion to get it fixed up. This has been going on since last November. What's my legal obligation? Do I chase it through the courts or do I just suck it up?
What did you pay, David?
For the dam, around about 20 odd grand.
It's still a matter you could take to VCAT.
I can take it to VCAT?
You can take it to VCAT. Now, I've got to tell you that it'll fill twice more before you get to a hearing at VCAT.
Yeah, that's what I was worried about. It's going to be 2 more years.
But I can't tell you that the Magistrates Court would be any quicker, and I can tell you that VCAT will be substantially cheaper. One of the things that you might consider doing is going to the builder and going to the person and say, what I'm prepared to do is I've got a quote for someone else to replace it a second time.
Yeah, all right.
And
all
here's
right.
my quote. What are we going to do?
Yeah, all right.
Right.
Yeah, because I want to get the fence up, so all the fences are down around the block. I can't get stock in. I can't get nothing on because we're waiting on him to fix the dam up.
Yeah, understood.
Yeah, no, and you can't. Gosh, waiting for VCAT right now. It's
Waiting for anywhere.
Well, this is very true. Roger in Mitcham. Hi, Roger.
Good morning.
Hello, Roger. How can we help you?
My brother is the executor of my will. His job is taking him to Mongolia for the next couple of years.
Yes.
If something were to happen to me in that time, could he perform his job as an executive from there, or should I nominate a temporary executor?
There's two approaches you could take. The answer is yes, he could do it from there. It would be a bit slow and a bit cumbersome, but capable of being done for there. What you could do is appoint someone else with your brother.
A joint executor.
Well, yes, but then what you do then is you then have a discussion. And if Roger's brother he returns to Melbourne before Roger passes on, then the deal is the other executor does nothing and we just leave it to Roger's brother. And so you die while your brother's in Mongolia, then a grant of probate is made to X, allowing Roger's brother to come in later and be the co-executor. There's a couple of ways you could deal with it. That probably is going to be the more efficient, but it might be more expensive. But then there's nothing theoretically wrong to prevent Roger applying for a grant of probate. Sorry, your brother. Yep.
There you go, Roger. That's interesting, though. Interesting. I'm interested to know what his brother's doing in Mongolia, but that is for another time. John in Ringwood. Good morning, John. John in Ringwood. Hello.
Oh, good. Thank you. Good morning, Ellie and David. I've got a question about tenancy and landlord type thing. It's very complicated. We've got we're an organisation, which I'm the leader of, and we've given a peppercorn rent from the state government.
Yes.
We don't pay anything. I think it's about $104 for the year or something, but I don't remember it ever been paying. Now, we got sublease. We got 3 tenants. Now, one of the tenants has this. They had to pay X amount of dollars in 2006, and then we had a rent review in 2016 to up it because it wasn't meeting costs with a whole lot of them, and we gave them 6 months' notice to object. They didn't object.
What's the question, John?
I'll get into the question. The question is that they've disputed that amount after the rent review was done, and they never objected. And they've been paying that rent, the new rent, for 5 years.
Yes.
And now they want to go back to the 2006 one X amount of dollars, which is a ridiculous amount of money.
John, it really depends upon the terms of the lease that you've signed with them. And there will be a rent review process contained in the lease. If you have abided by that, then the rent is what results from that process. And if it's not, then the issue is up for grabs, and it might be that you need to get some kind of assessment of a market rent. So you're going to need to get some advice in relation to the document you signed rather than the principle of whether or not, if they're paid it for 5 years, do they still have the right to complain.
Go back to the source. Tash on the Mornington Peninsula. Hi, Tash.
Oh, hello. Can you hear me?
I can.
I have a question about some money. My father opened bank accounts for all of his grandchildren when they were born. My son is now 20. That money amounted up to about $14,000. When my son was about 17 years old, his father decided that he couldn't be trusted with the money and coerced him into putting it into his dad's bank account.
Yes.
Which my son did, transferred it via NetBank or whatever that service was.
Yes.
And now he's refusing to give it back to my son.
Yes.
Yeah.
Your son
know how we can...
Your son has the right to commence proceedings against your ex-husband for recovery of the money.
And how would
sorry.
you go about doing that?
Magistrates' court, unfortunately.
Oh, okay.
Gosh.
All right.
Yeah.
I'm
Yeah.
doing a
So,
great job for the court system.
Well, yeah,
today,
you
Ellie,
are.
But
So that's the only
in the
recourse
event,
for Tash and her son?
it's not a VCAT matter. So the VCAT, the low-cost VCAT jurisdiction is not available because it's not really a trader type deal. And you could report the matter to the police, but I'd come along and say, well, he voluntarily handed it over. It doesn't mean it's not repayable. So I don't. In my mind, your claim is in the magistrates' court, Tash.
Good luck, Tash, to both you and your son there. Peter in Mount Waverley. Good morning, Peter.
Good morning to you both. In October last year, our neighbours and I signed a fencing contract to establish a fence between the houses. It was set up to be built in November and he didn't show. We made contact with him and he said there was a delay in material supply and he would ring us in the next week. We finally got hold of him in December and he was still using that same excuse. We haven't been able to make contact with him since, but we all signed a contract with him with one of the conditions that cancellation of order or part thereof will not be accepted without our written consent.
Yes.
Now, despite phone calls, messages and emails, we can't make contact with him. My question is, how valid is this legal contract and can we go ahead and get another contractor to build our fence?
Peter, does the contract have a time within which it'll be built?
No, there's nothing specified on the contract itself.
Have you paid him any money?
No, we have not.
All right. Is there anything that you know of? Because I had some fencing work done last year and I know that some fencing materials have been hard to get. So there might be, but I would be going to him and saying there's a drop-dead date for completion of the 31st of March, and if you don't, we'll get someone else to do the work. And you would then have the argument with him, because what you're effectively doing is you're terminating on notice. You're basically saying you're failed to deliver, so the reason for me bringing the contract to an end is not my change of mind, but rather your failure.
Right. We contacted this Consumers Affairs, and under Section 62 of Australian Consumer Law, we did what you've just said in terms of stating a reasonable time of supply has failed. Within 14 business days, we need a response either to set a date or we determine the contract to be invalid.
Yes.
We didn't hear anything from him. Does that condition in his contract that we've signed about that it has to be with his written consent, have we done satisfied all our obligations in terms of that because we can't get anything in writing from him?
Peter, my view is you brought the contract to an end. I'm not saying that he won't have a go at you for a cancellation fee or any of those things, in which case we go to VCAT for an order that I don't owe you any money.
He's done
on the
all
basis that he has refused to fulfil the contract. Your argument in that case is he refused to perform.
So he's not been present.
No.
Peter, good luck with that one. David, thank you.
Thank you, Ali. See you next time.
Yeah, indeed. And Virginia will be back in the chair next week, and she's got that homework, so she'll look forward to hearing the results of your research.